I just hit record. So yeah, I've got a lot of updates for you, and I'm so grateful for you making time to share and go over some of this stuff that we've both been working on together. But one of them is a reply from the office of the clerk of the Supreme Court of the United States. And to give everybody a little bit of background, I suggest you watch the other videos that Bill and I have done so you can understand more about this case and have the full context about what's going on. But the gist of it is that I filed a petition for redress of grievance pursuant to the First Amendment with the Chief Justice of the Supreme Court and the Office of the Clerk of the United States Supreme Court, because the clerk is acting as a gatekeeper, if you will, to avoid or to scan and deny any cases that don't fall within the rules of the Supreme Court from getting to the Supreme Court justices. And the clerk had, in my opinion, illegally denied a case that Bill and I worked on together, and basically said because that it did not conform to the rules of court, that they were denying my case to be submitted. Well, we both know that for many years, the court has held that substance over form is the rule of the court, and that you don't need to actually put something in the proper form in order for the court to hear it, because if they were to deny it on those grounds, it would be essentially denying rights, constitutionally secured and protected rights, because you didn't file some silly form. And the Constitution doesn't require any specific form. It just requires that you're invoking a complaint for a deprivation of rights. So the other issue of the petition for redress of grievance was that I had actually left a message for the clerk, and he returned my phone call, unbelievably. And I had called and asked him, I was asking about the proper procedure to submit an action in the court's original jurisdiction. And what he told me was, I'll read you some of the quotes. "We don't have original jurisdiction for one private litigant suing another private litigant. We would not accept a filing like that. The statute," and what he's referring to is 28 U.S.C. 1251, "is what allows us to exercise jurisdiction. Our jurisdiction is created by statute. 28 U.S.C. 1251 is the only authorization we have to file original actions. I hear you, but that's not the way our jurisdiction works. We are bound by statute." He then told me, "You can submit something, but it's not going to be accepted for filing unless it falls in one of the provisions of 28 U.S.C. 1251. It's not going to be accepted for filing. I just don't want you to put you through the trouble or expense of doing it." And then he finally said, "This is not new. We've had many people, I believe, who have tried, I just have tried here, to file original actions, and we've done the same thing, over and over. This is not going to be controversial here." So I submitted this, obviously, to his office and to the Chief Justice. And of course, I did it return receipt requested. And notably, I only get back the return receipt from the clerk's office, not the Chief Justice clerk. And I don't even know, there doesn't even appear to be a signature here, but I did get the card back in the mail, along with a letter. And anyone who's watching this, you can go to thespiritoflaw.com, and it's on the front page, or it's under the procedural history. You'll see the exact document scanned in there. So here's what the letter says. "Dear Mr. Berkey, in reply to your letter or submission, not my petition for redress of grievance, received December 14th, 2021, I regret to inform you that the court is unable to assist you in the matter you present. Under Article 3 of the Constitution, the jurisdiction of this court extends only to the consideration of cases or controversies properly before it from lower courts in accordance with federal law and filed pursuant to the rules of court. Please be advised the rules of court make no provision for the filing of a petition for redress of grievance. Your papers are herewith returned, and the rules of this court are enclosed. Sincerely, Scott S. Harris, Clerk. by Susan Frimpong, whoever she is. So I'll leave it there and open it up to you for any comments, because I know you're going to have a shit ton, and so am I. So have at it.
Oh yeah, I got to be careful. I don't run on too long here. As they obviously haven't heard, among other things, of the cases of Comezo, Colorado, Bill Grossman, 267 U.S. 87, ex parte Bowman, which is 1806, and the case of ex parte Milligan, Board Wall 266, all of which were original writs. And they had the jurisdiction to exercise it. They have to have it. Article 1, Section 9, Clause 2. The writ can't be suspended except in cases of rebellion or invasion, not COVID pandemic. So what they're telling you, if they're going to say they're controlled by 28 U.S.C. 1251, what's that telling us? That's a legislative tribunal, not a judicial court. And yet that's the only one created by Article 3. That's it. The rest of them, and there's been some controversy about that over the years, as you know, Adam. You go back to Martin B. Hunter's-Lessee, 1 Wheaton 304, that's his story, one of the top 10 justices of all time, ruled that the courts, the Congress had to create these courts. It was reversed later in Kerry v. Curtis, his last term on the court, and you read the dissenting opinion, which is unusual in those days. I think it's 3 Howard 245. And they came back and did another hatchet job, Sheldon v. Still, 8 Howard 441, claiming the Congress didn't have any, duty to create courts. Now, in that time frame, it may be viable. The reason being that at that time we had sovereign independent states admitted into this union, and those judicial courts had the concurrent jurisdiction of an Article 3 circuit court. In that case, you can look it up, Claflin v. Houston, 93 U.S. 130. The significant part about this being, it was decided after the ratification of the non-existent 14th War Amendment. Hasn't been reversed for that amendment, couldn't be reversed. Those judicial courts still have to be there one way or the other. If they're not, just the perspective here, and I didn't get all this overnight, trust me, I've been at it for 5 decades, 15 years all in. When it finally hit me one day, I said, my God, with no judicial courts, no judicial process, no right to trial by jury according to the course of the common law, a right still secured today to inhabitants of territories by the Northwest Ordinance of 1787 as reenacted by the first Congress, yet nowhere in sight in any of what fraudulently purport to be states. The big deal here is if you don't have any of that, and the jury, by the way, common law jury has the power to rule on the facts and the law. Goes back to the Magna Carta, goes back to Brailsford, Georgia v. Brailsford, 2 Dallas 402, 1797, well known to the framers of the Constitution and everybody who ratified it. But where is it today? They don't want you to know. So if we don't have that, that makes every law on the books at least a bill of pains and penalties, if not a bill of attainder, prohibited by Article 1, Section 9 or 10. The feds can't do it, states can't do it. Now, the big deal with that here is that if they can't do it, and they're doing it anyway, it strongly suggests that Article 109 and 110, among other provisions of the Constitution, have been repealed. If we can't get into a judicial court and ask the questions we're asking, and we do it with authority and with attitude, as you'll find, you're getting Madness materials, at spiritoflaw.com, and mine at youwinincourt@gmail.com. And I mean with authority. I have an 83-page unopposed brief on admission of new states that leaves nothing to the imagination about that. There aren't any. And that's the big deal. At best, we're now federal insular territorial possessions. And it could get worse than that. We could be merely appurtenant to the United States. That's the case called Jones v. U.S. 137 U.S. 202, and completely subject to the president as commander in chief. And doesn't it look like exactly what's going on to you out there today? People with Biden and all these executive orders he's issuing left and right. That's what they think they can do. because that 14th Amendment, and you'll learn that's never existed, created a subordinate body politic, which has no rights. The de facto National Socialist government is bound to respect. That's the way it operates. And good luck. The only thing you have is civil rights, quote unquote, ain't. And they only have to make that, come into play to make it look good. Remember the case of Rodney King back in LA in the early 90s, that sort of thing. That's it. Other than that, you get this qualified immunity, which the Fifth Circuit, by the way, who just ruled summarily against the Biden OSHA COVID vaccination thing, is now before the U.S. Supreme Court. Many of you probably know, oral argument coming up on Friday. And they just ruled, amazingly enough, to reinstate a case against a law enforcement thug down there in Texas somewhere, who had his knee on some guy's neck for 14 minutes, just like what happened in Minnesota up there, and killed him. And the case got thrown out initially because he had qualified immunity, meaning he had no idea what he was doing was wrong. What the hell is this? He's committing at least second-degree murder, and he doesn't know this is wrong. A big problem with this, as Adam well knows, is that if he doesn't know that, then he hasn't been trained, and that means that the territorial governor and or president haven't done their sworn duty to see the laws are faithfully executed. And that's a major get out of jail free card for us, because we're going to start serving subpoenas on the governors and the office of the president. If I serve one myself, I'm going to send it to occupant and get him into court and find out, because now he is the injured party. And for purposes of confrontation and cross-examination, we want to examine him to find out how in the world we fit within all these statutes they're using against us that only apply to corporations. I would love to ask them that question in front of an inflamed jury. And that's what we have the power to do. Confrontation and cross-examination, that's unopposed even in their corrupt jurisdiction. If you don't have that, you don't have a case. You've got no injured party, you have no relevant admissible evidence, and the case should be dismissed by what the Supreme Court has ruled would be a what's the word, neutral magistrate. Case is Toomey v. Ohio, 273 U.S. 510. And it goes on, just like I'm starting to do here. I'm going to get back to you for a few minutes and pick up.
Oh, okay. Beautiful share, Bill. Thank you so much for all that. I wanted to ask you about this because it's a question that I've been pondering a lot too. And it goes back to one of the things that Harris said to me. We don't have original jurisdiction for one private litigant suing another. Now, I know what you just responded to was basically that the writ of habeas corpus 192 has to be heard by the Supreme Court because there has to be a judicial constitutional court vested with the judicial power of the United States. But the question is, does the court have the authority under Article 3 to hear cases and determine cases of one private litigant suing another? And I think and believe, as I read Article 3, that it does. And here's the case from a quote from Cohen's versus Virginia, 19 U.S. 264. And here's what the court said at page 378. Well, let me back up a minute. What I'm saying is that the jurisdiction of the Supreme Court extends to two different classes of cases. And this is what the court was saying on that issue. They said, in the first case, I added the word case, their jurisdiction depends on the character of the cause, whoever may be the parties. This class comprehends all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. This clause extends the jurisdiction of the court to all the cases described without making in its terms any exception whatsoever and without any regard to the condition of the party. If there be any exception, it is to be implied against the express words of the article. In the second class, the jurisdiction depends entirely on the character of the parties. In this are comprehended controversies between two or more states, between a state and citizens of another state, and between a state and foreign state citizens or subjects. If these be the parties, it is entirely unimportant what may be the subject of the controversy. Be what it may, these parties have a constitutional right to come into the courts of the union. So basically, under the first class of cases, the court has original jurisdiction in all cases at law and equity arising under the Constitution or under treaties. Do you agree with that, or see some difference of opinion, or know of some case that has held otherwise?
Oh, not only I haven't, but you hit the key cases, Cohen's against Virginia, another quote from that case. And this is Chief Justice John Marshall, that infallible icon of Harvard and Yale, who was never wrong, was he? The Constitution gave to each person a right to present his case to the court of the nation, no matter how small the claim nor how little interest the community in its outcome. The framers of our Constitution thought it important in the interest of justice to create a tribunal superior to influence as possible in which that claim might be decided. Now you add to this that we can't get in there, and I'm speaking now about what I call lawful de jure jus sanguinis state citizens, and the hard facts are, and there's no getting around this, what are those? Free, white, male, 21. That's the way it was, that's the way it is, and will be until the Constitution is amended in accordance with that document, not in contravention of it. But the good news is that everybody else, Asians, Africans, whatever, are going to be inhabitants of territories or inhabitants of states, and they will have enforceable rights in that situation, not like what we have now. So yeah, I think Article 3, particularly when we can prove there isn't a judicial court anywhere in sight in the states, and if Congress doesn't, have any obligation to create any, where else do we go? That's the interesting question. And as Adam knows, I'm working on it in California in particular, but what's true here is true everywhere. Because we have Adam sent a FOIA request up there to the Secretary of State, and they fired back and said the Constitution of 1849 has not been repealed. In that case, Article 6, Section 1, California District Court. Constitutional common law court recognized contemporaneously by the California Supreme Court, pre-Taney, thank goodness, Ex parte Nolles 5 Cal 300. That court's there, and it has unlimited common law jurisdiction and jurisdiction of the same type in probate, which I'm working a case right now to get that case sent over to the county clerk, who's the ex officio clerk of that court. Black and white, dead bang, and from their own mouths. As we get it in there, attorneys can't even come into our judicial court. And maybe the parties can't either, especially if they're corporations, whether they happen to be landlords or mortgage banksters or whatever, because if they're registered to do business at all, they're registered with the Territorial Secretary of State. We are domiciled in a state judicial district. That's how big of a deal that is. And just briefly, another quick aside here, and I'll shut up, but look at the 14th War Amendment. What does it say? All persons born in the United States and subject to the jurisdiction thereof are citizens of the United States and the state in which they reside. Looks like plain English, it's not. Persons should be capitalized. The secret intent was to make citizens out of corporations. You can check that out. Look at Connecticut Insurance v. Johnson, 303 U.S. 77. Read the solo dissent of Hugo Black on this issue. So that's what they did, was made citizens out of corporations, subject to the jurisdiction thereof. And for goodness sakes, didn't we, the people, ordain and establish this Constitution to ensure the blessings of liberty to ourselves and our posterity? We own the place. How can we be subject to that which we created? I'd love to hear that, John Roberts. Think about it. So we have that in the mix. And citizen of the United States, capital U, capital S, small c, that's exactly reversed. And of the state in which they reside. We don't reside in any state. We have a domicile in a state judicial district. And the big key here is, among other things you'll learn when getting my materials, uwinnincourt@gmail.com, that the IRS in particular functions on the principle, quote unquote, that a taxpayer, quote unquote, can be found for all jurisdictional purposes in the District of Columbia. Article 1, Section 8, Clause 17 may be the only place the tax is valid, if it is at all. But that's what they think they can do. We have no right to boundary respect, no right to trial by jury, no judicial court. Just pass the laws and get it over with. I mean, that's a democracy. It's nothing remotely related to a federated Republican form of government of defined and limited powers. Not to mention the fact that states are also secured that right by Article 4, Section 4. And here's what happens so often here. I'm going to shut up, I promise. But there are several areas like this. This is a key one. Article 4, Section 4. A Constitution has been around 230 years. The 9-0 part of the U.S. Supreme Court has made one ruling on that issue in 1842, and they ruled it was a political question. Case is called Luther v. Borden. I think it's 7 Howard 1, and it hasn't been there again. You know, am I the only person or only people like us that think like this? And we can't get issues like this into the court that not only need to be resolved, but resolved in our favor. And that starts the process of restoring the original government we had. It wasn't perfect, but going back to that point, now what happens is you have much less power in my hometown of Washington, D.C., not a whole lot in Sacramento either. It all goes back to the county seat. Much more efficient, much less expensive, much more changeable. How's that for a trifecta? That's what we're supposed to have. Now, let me shut up here a minute and get back to Adam.
You're all good. Moving on to a different issue, you know, I just want to share that I never would have believed all of this that I'm sharing here now, that there are no judicial constitutional courts and that there is no Republican form of government, unless frankly, I, you know, went and did my own homework. I mean, there's people all over YouTube that are saying this and talking about admiralty courts and that the whole system has been overthrown by, you know, wealthy banksters and powerful elite that are in the shadows. And that's all fine and dandy until, you know, you still have this belief that there's some hope to be had out there, that there's actually a court that you can go to where your rights are going to be recognized and where there's going to be justice and equality and fairness and you're actually going to be heard. But I had to go through all of that and see that it wasn't true, at least not up to this point. And so anybody who wants to see this process that I've gone through and to see it in their words, not mine, to actually see the evidence of every single submission, or at least most of them that I've made to each of these different courts. A lot of the documents from the docket are on my website. All of the Public Record Act's requests, all of the complaints I've made, they're all there on the website for you to see it. It's not me saying it. The evidence is there. You can read it and verify it for yourself. And as far as I know, in all of my research, while there are many people that make these claims and accusations all over YouTube and the internet, I have never seen anything like the site that I have created with all of this evidence there for anyone, anywhere in the world to look at and see for themselves and verify. So that's all there. But because there was no access to a court, not even the Supreme Court, as you're seeing in the letter, the clerk is going to throw the case out before it even gets there, or when it gets there, before it gets to the justices. I started making complaints to law enforcement. So this case actually originated in the city of Newport Beach, which is in Orange County, California, where I am. And I started talking with a detective sergeant. His name is Darren Joe. And I spoke with him, I believe it was over the course of 4 weeks. And we had 4 separate phone calls, which were all recorded by both me and the police department. And all of those are up on the website now under procedural history. And several of them, or at least one of them, is over an hour long. Ultimately, at the crux of it, he wrote a suspicious circumstances investigation report. And he says in the report, you know, basically that Adam complained that his 8th Amendment right had been violated, and that the crimes of fraud, theft, forgery, and robbery were being committed by judges involved in this decision, blah, 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 blah. He says, I contacted the Orange County Deputy District Attorneys And of course, their names are blocked out here. To discuss this case, both DAs were in agreement that criminal courts have no jurisdiction to intervene and sustain civil judgments. They also stated that the Constitution protects people against the deprivation of rights, liberty, property, of life, liberty, or property in circumstances when they are not afforded the benefit of the due process of law. The DDA advised me to recommend Adam either file a motion for rehearing of his cause through the appellate court or petition the Supreme Court of the United States to hear his case. I relayed this information to Adam, who adamantly disagreed. Blah, 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 blah. This case shall be categorized as a suspicious circumstance due to the lack of probable cause to indicate a violation of the California Penal Code has occurred. So can you believe that they actually state that the Constitution protects people against this deprivation of life, liberty, or property? And yet I gave him evidence in my case that it didn't do that. And then they send me back to the courts. So then after this, I filed a petition for redress of grievance with the City Council of Newport Beach. And within 24 hours and 6 minutes, I get a response from the city attorney, and he says, in our office has reviewed this matter, and it is our opinion that the police department has acted appropriately regarding your complaint. In our view, this is a civil dispute that is properly handled by the judiciary and not by the police department. Hence, the city of Newport Beach will be taking no action related to this matter. So then I asked him for, I said, thank you for your response. Could you please share the factual foundation and legal basis of your findings and conclusions that support your quote unquote opinion? I believe I have a right to this information given the fact that I filed a petition for redress of grievance pertaining to deprivations of my constitutional rights, and so that I can properly inform my representatives of changes I feel need to be made in our law, if any. He writes, unfortunately, our office is unable to provide you with legal advice. As stated below, it is our opinion this matter falls within the purview of the judiciary. So this is like sending someone who's been the victim of domestic violence back to the abusive spouse to get remedy. I mean, it's just flatly fucking absurd. So what I'm working on right now is another petition for redress of grievance or rebuttal to this report, which they said I could make. So I'm doing it and calling out all of this stuff. But one of the things that I discovered in filing a Public Records Act with the city is that the so-called police detective sergeant that handled my case does not have an oath of office for either police officer or police sergeant. So not only is he not in office and cannot adjudicate my complaint, let alone decide issues of my constitutional rights, he's also taking money from the public treasury, which he has no right to do. And every single arrest that he has ever made is invalid because the California Constitution in Article 20, Section 3 requires that every public official, before they take office, both take and subscribe the oath that is required under that section. And according to the city, he has done neither. So, or has not, they don't have records of the subscribed oath, despite the fact that he has been appointed to both the positions of police officer and sergeant in the course of his career. So, yeah, he basically adjudicated my case without any lawful authority. And so, I mean, that's where we're at. But again, if you want to see all this documentation, go to the website. I've kind of changed the format on the first page. It's now a blog. So any updates that I do will be posted in reverse chronological order. And you'll be able to download all these audio files and see it firsthand for yourself. Not my words, theirs.
Wow, I've been thinking too. Another thing I'm going to be doing, and I'll keep you in the loop here, is I've not had any luck with 904 either, as you know. And in fact, as you also know, I have a summary ex parte 12-6 denial of a non-statutory federal writ of habeas corpus by the deputy clerk of the California Supreme Court. One sentence, the questions you ask are beyond the jurisdiction of California courts as they appear to raise federal issues. They don't have federal jurisdiction. And yet, when I was enjoying my 7-month vacation as a political prisoner in Columbia, South Carolina, news report came on one night where they had a local attorney, and I don't know if this ever got into the courts per se, but making the claim that a transgender entity, whatever that is, has a right to select its public bathroom because taking a crap in a government-funded bathroom affects interstate commerce. They don't have that jurisdiction in San Francisco, Sacramento, Los Angeles. What the hell is going on here? So I don't know. I've been through the mail here, but it occurred to me the other day. I saw an article I downloaded. I'll send it to you a bit later. That was talking about this Democrat that was the chairman of the House Judiciary Committee. And I said, that's worth trying out, and ask him to ask them, because he'll have access to maybe John Roberts and who else, what the hell they're doing there. And give them the quotes that we just said out of Collins versus Virginia at the very least, and ask how come it is we can't get into the only judicial court that apparently remains in existence. So this may be the next step up to doing this. And I mean, it's got to stop somewhere. I'm already, like I say, 15 years all in, 5 decades. And it was what I was put here to do. I wish I had known 50 years ago in high school when I was out of Washington, D.C. but better late than never. And when I realized all this, and you're not going to get it all at first either, I get that. I didn't. I was the slow learner. It took me 10,000 hours in those musty old stacks of law books and UC Berkeley when I could get into Bolt Hall and Hastings College. And that was a good way to learn back in the 80s before the internet and all that. And it's a lot more than names, dates, and places. Just as Adam very well knows, it's the connections you can make, the perspective you get. And you read all this stuff, especially from an earlier era, and especially the admission of Maine and Missouri, the most important issue ever to come before Congress. Because if that didn't go the way it did in 1819, the United States would probably have been out of existence at that point. I'm not going to go into that story, but you go in and you read stuff like this, and you read Congressional Globe, which is what it was then, and read how these people were talking who understood the original intent. And it's not like Pelosi and Schumer and all these idiots today that don't have a clue. You read this from people that did have and understood the stakes. And what happened 50 years later with the 14th Amendment, they'd be just as upset about that as Adam and I are, because they did away with the states. As soon as that amendment was confirmed, July 28, 1868, there have been no states in existence since then. And as you'll learn what that means across the board, we have issues now that violate all 6 articles of the Constitution. Couldn't care less about the 14th Amendment, and not even due process, although due process, if I were to make that argument, I would argue that any laws enacted, quote unquote, by a Congress in which we're not only not represented in any part of, but there are 0 qualified members in the House, 0 qualified members in the Senate. If that doesn't violate due process, it's real hard to know what would. And that's been true for over 100 years. That's just today. And there's a lot more to it, as you'll learn. Getting my materials, it's astounding. I wouldn't have believed it either when I started out. And in fact, speaking of ignorant, I was at the head of the class. So what did I do in 1968? Volunteered into the Vietnam War at the height of the Tet Offensive in the Marine Corps, for crying out loud. And my dear beloved mom said, "You're not going to get him." And she put a curse on the Marines, and everybody laughed. And I go over there to Port Holabird to go to Paris Island, and the sergeant takes one look at me and says, "If you lost your glasses, how would you know who to shoot?" Well, I know the right answer today, which I didn't at that point. I would have said, "Fine, no problem. Give me an M16, point me back down the highway to Washington, D.C., 1600 Pennsylvania Avenue. I'll take care of the problem." That would have been the right answer. LBJ, who got in there, by the way, we won't go into the JFK business right now, but one of the big deals was he had just issued an order that would have taken us out of Vietnam, and it never happens. Johnson, the first day he gets in office on Monday, the 25th, reverses that order, and we're in Vietnam for the next 10 years. too long of a story for now, but trust me, the short story is that I have the shortest tour of duty in the history of the Marine Corps, 3 hours. Would have been quicker than that if we'd have had cell phones in that time. But it's just, I mean, this just has to stop here. And whether, I get across the Red Sea, I don't know. Family history tells me I got a good 8 or 10 years left, maybe more than that. And the COD for me isn't going to be COVID. It's going to be pneumonia when the time comes. We'll see about that part. But I'm still alive and kicking here and making as much trouble as I can and setting records that all of you can use out there, just like Adam is doing. And you say, yeah, it's not just us saying it. Look at what the hell is going on here. Are they this colossally ignorant in these official government positions? If so, what kind of a job qualification is that? And we show it to him simple, and Adam does it much better than I do. He's much nicer with this paperwork. I'm working on that and trying to get there. It's a lot of pin-up anger over the course of 5 decades. But, especially with local actors, I think we are well positioned to keep them in the loop and be friendly, because they're major beneficiaries locally, because that's where most of the government power is. They should be our allies. If we get that working and get it back to that way, now the government is a lot more like what it used to be and what it could be again. And then we can make changes from there and do it the right way and make any changes we want, to improve what we already have. I mean, it's not hard. And just another quickie before I go here with there's so much talk these days about, especially in California, being very upset because their House delegation got reduced from 53 to 52. Do it once every 10 years. Who the hell cares? I mean, if you read the Constitution, and I was guilty of this when I was growing up too, I didn't read it closely. Article 1, Section 2, racial relationship, 30,000 inhabitants to 1 representative. With 325 million people, California shouldn't have 53. It should have 1,300. Think about that. That's the Republican form of government that we're supposed to have, and it's much more than numbers. I'm not going to go into that now, but trust me, it's much more than just the numbers involved. So we're simply not represented. It's easier for the corporate people, especially the New York bankers, to control everything behind the scenes, and that's what they've been doing for arguably at least 150 years. And in fact, Lincoln, I think what the events at Ford's Theater occurred after he wrote a private letter to a friend that I got a hold of, expressing thanks. The war was soon going to be over, which in November 1864, they knew it was. But he said he saw a greater enemy, and that was the corporate money interests in New York. And that's what I think caused the events at Ford's Theater. Unfortunately for Congress, they thought they had a friend in Andrew Johnson, and that did not turn out to be the case. And in fact, he's our greatest president. And even if I had read his veto of the Civil Rights Act of 1867 when I was in high school, my life would have been different. That's how strong this stuff is, but they never want you to know anything. All we heard about Johnson was he got impeached, which was true. He survived by 1 vote, which was true, but they never told you anything about it. And this is black and white, like they say in CIA language. So if they want to tell you that Johnson is the best president, they're talking about landslide Lyndon. Andrew's at the bottom of the list because of what he did. He did his job and tried to protect the American people and our government. And it didn't work out, but it wasn't his fault. He did everything he could do. So that lesson alone will teach you that anybody that they're out there ballyhooing and they love them and this, that, and the other, all the friends of democracy, quote unquote, which my first law teacher accurately described as 3 wolves and 2 sheep voting on what's for dinner. And I know it in passing, they have a democracy in Pyongyang, North Korea, don't you know? And the last election had a tremendous turnout. 99% of the voters showed up. Of course, behind the scenes, what they don't tell you is over there, not voting is an act of treason. And they probably just take your ass out in the courtyard, shoot you, and that's the name of that tune. You don't have to worry about it again. That's a democracy. Is that really what we want here? Is that what the framers had in mind in 1787? I'd love to hear it. Goodness, everyone want to get a bit. I'm going to get back to you.
That's okay. One thing I don't hear discussed very often, although I think a lot of people that have gone through some of the situations that we have understand it, is that to the ordinary person, it seems like there are courts. It seems like there is a legitimate police force. It seems like there is a legitimate legislature, and that all this stuff, now they can turn on the news and see that there's problems, and people are upset about political differences of opinion and whatever. But generally speaking, they all believe that this mirage that's here in the form of a lawful Republican government is in fact not a mirage, but reality. And it's not until you actually, lack of a better term, become a victim of it. And you try to, if any of you want to test something, if you've never tried this before, call your representative, see if they'll call you back. I had my friend Virginia do it. No callback. Multiple times she called different representatives. No return phone call. So you can't even get a hold of these people. How could they possibly be representing you? They can't. And then when you go to them with an actual grievance, you don't either A, you don't get a reply, or B, if they do reply, they don't actually follow up. They don't make a determination. It's all smoke and mirrors. It's all bullshit. And so that's one of the reasons why I've done the work that I have in my own case, but also to share with others, to put this evidence out there so that you can see. So one of the other things I wanted to bring up, I actually already have, is what the clerk of the Supreme Court says. Please be advised, the rules of this court make no provision for the filing of a petition for redress of grievance. In other words, if the Supreme Court hasn't made a rule that you can file a petition for redress of grievance, they're not going to recognize the validity of it, and you can't. Despite this, the First Amendment says that Congress shall make no law, blah, 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 prohibiting, well, let me read the whole thing without going blah, blah, blah. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peacefully to assemble and to petition the government for a redress of grievance. That right is there. And it says that Congress can't make any law forbidding it. So how did the Supreme Court, through rules of court that were never submitted to Congress, that were never submitted to the people, suddenly overrule or amend the First Amendment? How does that happen? It's mind-blowing. So I don't know what's going to happen next on that front, but clearly there is nothing in the rules of the United States Supreme Court that allow you to file a petition for redress of grievance. And yeah, I think you may be onto something going to the Judiciary Committee of the Congress, but we both know that that's going to be like, they'll wipe their ass with it too. So,
we'll see. I mean, this looks like, and then again, as you know, Adam, we also had the other issue where you got told by this idiot clerk of court that it was Rule 1 of the Supreme Court that prohibited him from filing the documents. Thank God they didn't cite the FRCP, which is a story for another day. But if that's true, what we want to know, and I've got their official publication, the practices of the Supreme Court from 1993, Rule 1 wasn't anything like that at that time. What we want to know is when and how did it change, and what notice did the public have that it was going to change? No opportunity to be heard. They can't do that any more than any other government agency can do. That's a great case called Windsor v. McVeigh. We'll talk more about that later, 93 U.S. 274. But without any notice or opportunity, they're in effect taking themselves out of being a judicial court and relegated to a legislative tribunal. Is that really what happened there? And they may be anyway. If Biden can increase the number of justices with an executive order as the president, that's the same situation. That's how strong that is. And they've been through that back when FDR was in there trying to do the same thing in the New Deal era in the 1930s by an executive order. That simply can't happen that way. I don't even know if Congress could do it. Unfortunately, the Constitution doesn't have a definite number of justices on the court. It's been as few as 6, as many as 10, but 9 since the war between the states, more or less. But that whole thing, it needs some correction. In fact, if they want to get rid of the business, what they should do is create a supreme tribunal for corporate entities. Get them the hell out of our courts. They'll have a hell of a lot less to do there, and it will be much easier That's a really much better fix than what they're talking about now. Let us have our court that we should have anyway, especially if it's the only judicial court anywhere in the country, and we'll take it from there. So this stuff, I mean, you just don't know where this is going to end.
I
I
think
shouldn't be
it's
surprised by
important.
anything that happens these days, but go ahead.
Yeah, I think it's important to note, and it's something that we've talked about a couple of times, that I don't also hear a lot of other people talking about, is that what we're really talking about through law, and what I'm trying to embody in my website named The Spirit of Law, or trying to convey, not embody, is that in many ways, the intent of the founding fathers, as I've come to understand it, and in a lot of these laws, there's a spirit to it that really speaks to fundamental fairness and equality, and what most of us have an innate sense of justice being. And what's happening is that, or has happened, is that this is being hijacked by people that are mentally ill. The word that comes to mind to describe them is sociopaths. And it's not so much that the law is corrupt, it's that this illness, this psychological disorder, has rooted itself very deeply in all levels of our state and federal government. And it is so deeply rooted and has been there for so long that this is what most people consider to be normal behavior. And so when someone like you comes along, or me now, and says, hey, wait a minute, this ain't even remotely what's going on. Look at the behavior that they're doing. None of this is constitutional. None of it is lawful. It's criminal behavior. And I think most people have no clue that this is going on. So I think that that's really important to note, that that's essentially what we're dealing with is psychologically and emotionally and spiritually people that are really unwell and unstable. And so it's really, I'm not sure how far we're going to get, because we're going to them, and I'm not saying all of them are, but we're going to them to solve the problem. And you can see how well that's going. I don't know what the solution is essentially, but it may come to another revolution where these people are forcibly taken out of office in order for change to be effective. I don't know. I don't know what's going to happen, but I just wanted to add that point, is that try arguing with the sociopath. You might as well be a sociopath yourself if you're going to try and argue with one, because you're not going to get anywhere. And this is what they do. Just like with my paper, they just say, oh, we don't have to give you a reason for our decision. Get out of the court. Your arguments are frivolous. And all of this treason, fraud, and deceit that they're doing without any authority whatsoever, all the while committing the fraud upon the American people that they're lawfully in office and they're abiding their sworn duties and all of that. So anyways.
Yeah, I know. You have to wonder. I'm frankly glad to be in the generation I'm in. I don't know what's coming down, for the future, but my, kid who's 35 now, I've been helping, especially with his U.S. history final exam he got. And by the way, we did that. We started out to do it on the bank holiday declared by Roosevelt in 1933, a week after he gets into office. And we switched and ended up doing it on the war between the states. But during the first part, I looked and I knew damn well that Roosevelt was using the Federal Reserve Act of 1913 for emergency powers to do what he did. And I then also saw, and I should have known this, he was also invoked the Trading with the Enemy Act of 1917. And that's what they think we are, undocumented enemy aliens. In any case, we didn't do it. We backed up and we did it on the war between the states. And I gave him a lot of historical facts that probably didn't show up in the textbooks his institution of higher learning was using. And I found out later he actually got a 0 on the report. Fortunately, he passed the class anyway. And I learned a bit later they upgraded it from a 0, I don't know to what. but they're going to be hearing from me, higher learning. And I'm going to say, gee, just because you have one of your students that got a hold of someone that knows a little bit of the truth about what went on in American history and wanted to report it and did so with facts, and he gets a 0. This is what you call an institution of higher learning? Is that really how it goes these days? And on this point, Irvin Chemerinsky over in Berkeley, I understand a year and a half ago, he relegated the only constitutional course they have at Berkeley on that law to an elective course. And that made good sense to me. I mean, why do you want to waste time and money, studying something you're never going to use? They simply don't recognize it. And I'm sure that's like that all over the country. Wasn't it one time? I think when Rehnquist and O'Connor were at Stanford together, and that was in the 40s, they at least got a little of this information. I don't know that my mom got a whole lot when she was in school in the 30s. My grandmother, I've got her hand-me-down textbooks from the late 19th century, and they look like books you would see at Harvard and Yale today. They learned a lot, but then they were in school 6 years, most people at that time. But you read these books, wow, I wish I'd had those when I was in school in the 60s. Damn. So, and the education is a big part of the key. And a big part of that is, I'm now going to be telling people to demand your right to trial by jury, which you're never going to see. I haven't seen one. I'm not going to see it. You won't either, because with my materials, you get at the moment almost 600 jury instructions. I think before Easter, it's going to be closer to 700 with current events. But we have a right to get our theory of the case to the jury, who can rule on the facts and the law. Unless or until they overrule that overtly, and it hasn't ever happened, and I don't think it's going to, given the history of trial by jury. That's the bottom line. So it's going to force them to either go to trial or dismiss charges, or maybe make a sweetheart plea deal, time served, and anyone that gets in that situation, we'll talk about it. I think we can do that with a fair amount of safety, as long as you take care of the paperwork and be sure you're under extreme duress and coercion. But they won't go to a jury. I mean, for openers, they don't have courtrooms for all these jury trials. If everybody demanded one, we put them out of business, because it'd be speedy trial, which is not one of my favorite issues. But they can't possibly do it. And 95% plus of even the criminal cases end up with plea bargains. What does that tell you? So we have a lot of power in it. You'll learn a lot more. Send me the email, youwinnincourt@gmail.com. It's an astounding amount of power we had behind the scenes. And I felt it in Colombia. I was standing there, having gone across the country for 2 months in courtesy of 4 different federal unmarked military aircraft. And I'm standing there in a red jail suit, manacled hand and foot. And the judge reads the charge, practicing with the law without license. And I laughed. And I said, yeah, I don't practice it. I get it right the first time. And she said, well, we got to check and be sure you're competent to represent yourself. And if I could have thrown up my arms, I would have. Barfetta, Beretta v. California, Judge 422 U.S. 806. The problem with that is the U.S. Supreme Court ruled in Barron v. Baltimore, 7 Peters 243, 1828. Bill of Rights doesn't apply to the states. Stunned the courtroom into silence. That's what we have the power to do. I never want to lose that feeling. And you see that, and it's just, wow. They didn't know what to do. I didn't hear 2 words from the prosecutor the entire time I was there, which is another 5 months for different reasons. But I had them, and everyone in the court knew they were the ones in trouble with the law. That's the feeling we want to have. You never want to let that go. That's true. And I think it still is, because they wouldn't have that feeling if at least some serious parts of that Constitution didn't remain in full force and effect. And I was going to beat him to it. And I laughed at him, by the way, out here when they arrested me in a library to start this case. That's hard to do, to get arrested in a library. But I did, and I was laughing even then, because I knew, that's how strong it is. And it took a lot longer than it should have. But I got back, minimal damage, took 4.5 days, the bus trip from hell to get back. But I did, and I recognized from that experience, and I did, and Adam has seen it, I have an 18-page hand-printed writ of habeas corpus that I sent to the Supreme Court, and this joker was still apparently the clerk even at that time. Now, they took no official action on this, but I know they got a call in Colombia, get him the hell out of there. We can't rule on these issues. I'm convinced that that's what happened. 18 pages, 40 case citations, no errors, alone from a jail cell. And if you can find an attorney out there that can do that, I would love to hear it. I mean, that's the ability I have and that Adam has. And you don't need to be that good, by the way. The ignorance is so colossal on the other side. You talk about 2 or 3 key issues and do it, with intelligence and with facts. You're going to shut them up too, because they can't go there. Because if we prove treason on the record, they're not acting in any official capacity. Therefore, they are personally liable for what the Supreme Court calls in Cohen v. Virginia, acts of treason to the Constitution. That's how important that Cohen's case is. Treason, that's exactly what they're doing. That's the leverage we have. As long as that Constitution still exists, and apparently it has in good faith for 230 years, there are those that think we got sold out in the beginning, which is a video for another day, and that might to a limited extent be true. But even so, it's been there for that long, and everybody says, well, that's the supreme law of the land. All we want to do is hold them to it. If we do that, the game is over. We get our nation and republic back, then we can go down the road from there. Oh, geez, I've gone on again, Adam. I'm getting this back to you.
It's all good. I'm good here. I'm so grateful for your time. And, I think we both shared a lot of things. And again, all of this is on the website or, amongst Bill's many videos that he has posted on his YouTube channel. So thank you for listening.
Thank you too. Okay.